These standards had been fixed more than 70 years ago, and these cases were clogging up the system. I could persuade the government to say, just increase the limits by twice or thrice, and it ended up closing almost 30,000 cases. So this is possible to be done, but for which we must go into the record rooms of our courts. If these cases are eliminated, we can arrive at a realistic figure of the actual live cases that can be considered arrears if they have crossed their life cycle. And that won't take, as the popular myth goes, 300 years to be disposed of. So how do we go about doing this? For this to happen, we need to engage an army of law researchers, young law graduates, or even sometimes students, and perhaps retired judicial officers in the various states. These can then delve into the court record rooms and categorize cases that are dead, those that need a formal ritual of disposal, and so on. In criminal cases, this will require the cooperation of the police. And of course, the lawyers will have to help. We can also persuade governments to drop cases of little monetary value. Our judges can then spend their energies on far more serious cases that require urgent attention. These measures will reduce the pendency docket considerably. This can certainly be done in the next 5 years if we begin now. The 2047 docket position will look much more manageable if we manage to achieve this. Then, this is my favorite line in most of my lectures on the working of the courts. Judges alone are not responsible for the delay in disposal of cases. This is a myth and requires to be broken. The statistics tell us that judges are doing their possible best, with the case clearance rate being 90% and over. Yes, there are judges who are shirkers, but then there are those among them who are ant-like and do the heavy lifting of the overall case load. It would be fair to state that at all levels of courts in our country, there are around 20 to 30% of the serving judges who are punctual, punctilious, conscientious, hardworking, efficient in court and case management. We should be worried about the remaining that aren't. There are several pressure points that affect the output of judges. The pressure of case overload. I've had young magistrates come and tell me, even if I work from 9 in the morning to 7 in the night, at the end of the day, I have some 50 more cases on my docket, although I have disposed of at least 60 cases today. And that can be backbreaking. Then there's the pressure of recalcitrant and unhappy lawyers and litigants, the anonymous complaints of corruption, anxiety about disposal, intense media glare, strictures from the high courts and the Supreme Court. The list can be endless. Above all this is the stress that judges undergo in dealing with human problems day after day, hour after hour. You know, if you're a family court judge, on an average, on a daily basis, at least there will be 5 cases where in the chambers you will be asking a 5-year-old, does the 5-year-old want to go to the mother or the father? And in many of those cases, the 5-year-old will be turning back to the judge and asking, why should I choose? And judges are supposed to do this day after day. The mental fatigue of judges is seldom acknowledged or accounted for within the system, and I mean judges at all levels, at the levels of the district judiciary, the High Court, and the Supreme Court. Then there is a problem, a real problem of uneven distribution of work. In a state, some courts in the major cities have a disproportionate caseload compared to their counterparts in other districts. For instance, in a medium-sized state like Odisha, the Court of the Judicial Magistrate of Cuttack will have a caseload of 1.25 lakh cases, whereas the counterpart, say in a remote district like Noapada, will have a load of not more than 10,000 cases. As much as a huge load can slow down even the most efficient judge, lack of work can frustrate even the lazy judge. And this is true of the high courts too. You would not believe it, but there are courts in the northeastern part of this country, high courts, that hardly have a caseload of even 3,000 cases. I checked these figures just before coming for this lecture. The entire pendency in the Sikkim High Court is 328 cases. In Tripura, it is 1,609 cases. In the Meghalaya High Court, it is 1,495 cases. And now compare it with the Allahabad High Court. It has a caseload of over 12 lakh cases, with 40% of those being over 10 years old. This is something that judges don't speak about much, and therefore the public doesn't know about much, that judges are expected to be multitaskers. It is, of course, a myth that outside of the court working hours, judges have a jolly good time. Most of the judges, and at all levels, are working beyond court hours, attending to administrative tasks. And what are these? Examining building plans for new courtrooms, purchasing computers and furniture, choosing uniforms for staff, examining complaints against judges in the district judiciary, deciding whether to order an inquiry, fixing the menu for the next grand event being hosted by the court, preparing for lectures to deliver at judicial academies. I became a judge in May 2006. I was fortunate that the senior bench partner was Justice Mukul Mudgal, somebody I had known from the bar days. And he mentored me for the first few months. And within the first 10 sittings, he'd asked me to draft a judgment. So I was very excited. I'd prepared the draft. And it was around 4:30 or 4:45 in the evening. We had got off the bench at around 4:15. So I knocked on his door, opened it because I wanted to show him the draft. And I find Mukul sitting in his chair and holding a plastic mug like this. So I said, Mukul, what is happening? He said, Buckets and Mugs Committee. So 3 judges of the High Court sit on the committee to decide what towels to buy, what plastic buckets to buy, what mugs to buy. Basically, the buck stops with the High Court judges. And you're supposed to have a working knowledge of all of this, which computers are good, and which food tastes good, and from where, who should be the caterer. You know, the support staff will prepare the background papers for you, but ultimately you take the call. And so from the most, banal to the most, grave, you're supposed to have the answers for many of these administrative tasks. For district judges, all this and having to be on high alert not to displease the boss, who's the High Court judge, who has to write your annual confidential report, the ACR. There are growing instances of women judges facing the trauma of sexual innuendos and harassment at the hands of male colleagues. We are yet to devise satisfactory mechanisms of fairly dealing with these complaints. We should remember that all of this applies to court staff as well. So when you have news items that, this High Court judge sat till midnight, that High Court judge sat till 2 a.m. in the morning, we seem to forget that the judge has a supporting staff which have to stay back at least 2 hours after the judge leaves to wind up the actual court proceedings. So it is a big punishment on the court staff if a judge chooses to keep working beyond court working hours. And it's a myth that the judges in our district judiciary are actually independent. They're anything but. They're totally dependent in their day-to-day functioning on the cooperation of the local police and the local administration. They issue so many warrants for production of the accused, for production of witnesses. If the local police doesn't cooperate, nothing can move in your court. In sum, our judges and their staff in the courts have always been overworked, punching way above their collective weight in working conditions that are far from ideal. So then, who else contributes to the delay in disposal of cases? First and foremost, as all lawyers in this room will know, the state, by which I mean the governments both at the states and the center. By taking arbitrary decisions, or by not deciding at all, or by unthinkingly criminalizing normal activities in a democracy like peaceful protests and unnecessary arrests, government drives the people to the courts. This explains why, despite the delays, costs, and uncertainties in the court system, the filings have grown over the years. The other problem is that the state's capacity to litigate can outmatch even the richest conglomerate. If the state loses a case at any level, it will appeal and keep doing that till the Supreme Court. It could be an increment of 100 rupees given to a Mali in a government department, or a pension of 300 rupees to a widow of a deceased government servant. Everything has to be appealed. And if the private individual succeeds, there is no guarantee that the government will accept and comply with the court order. The contempt roster in our courts is burgeoning. Repeated litigation policies of the state have remained on paper. There is simply no will to implement them. The lawyers engaged by the government are also to accept the blame to some extent, because it is they that advise the government on the next course of action. The fear of being blamed later for favoring an individual litigant makes both bureaucrats and government lawyers to play it safe and advise going in appeal. Also, since the fee is low and tied to the volume of work, there is an incentive to keep filing cases, however frivolous. At another level, government will not employ enough counsel and on time and hand them the relevant records and instructions. So often, as private lawyers, we've been asked by those appearing for the government to give them the copies of the papers because they simply don't have the copies of the papers. Many of these appointments to the government panels are distributed as largesse with no real relevance to the expertise required. All this leads to numerous adjournments on account of non-availability of the government counsel, whether as a public prosecutor, a government pleader, or a law officer. If they do appear, they are instructed poorly or not at all. Reply affidavits are seldom filed in time, records are never produced within the time stipulated, and judges at all levels are helpless. They can be frustrated, but they can't move without the government producing the records, and they are forced to accommodate these requests. All this can and has to change if there has to be in 2047 a better functioning judicial system. Then let's talk about the private lawyers. They fare no better. In the marketplace of lawyers, 80% of the work in any court is with 20%, if not less, of the lawyers in that court. At the level of the district judiciary, especially in the remote towns and districts, full-fledged trials of civil and criminal cases rarely take place. There is an increasing tendency to only argue interim injunction applications in civil cases and bail applications in criminal cases. If an eyewitness stands firm and cannot be won over, the lawyers will find ways of deferring the trial. In a court of a junior division judge, the local bar can be domineering. A judge who refuses adjournments is unpopular, is labeled as arrogant and insensitive. Strike calls are given over trivial issues. Most lawyers who practice in these courts have other avocations to keep their income flowing. And we have a Bar Council of India and Bar Council in the States that are reluctant to hold inquiries into complaints of professional misconduct and in good time. These lawyers also resent the provision of free legal services, mediation, and appointment of salaried defense lawyers employed by the legal services authorities. But not everything is so dire. Just like there are a few judges at all levels who are conscientious and consider themselves accountable, there have always been, and I'm sure there will be, a relatively small number of lawyers, almost in every bar, who view the legal profession more as a service to society and less as an opportunity for career progression. These lawyers take up cases at reduced or no fee and sometimes offer their services pro bono. This is apart from the panel lawyers of the legal services authorities, which is the state-funded public arm of institutionalized legal aid. We have had and continue to have private lawyer collectives and civil society organizations offering free legal services. I think the best example we can give is the person sitting here as chair, founding the Lawyers Collective, which has rendered legal services. Then we've had Justice D.K. Basu. Yes, the same Justice D.K. Basu of the D.K. Basu versus Union of India fame, who headed what is known as the Legal Aid Society of West Bengal, LawSweb. Then we have had the Jagdalpur Legal Aid Group headed by Shalini Gera. We've had the Majlis, Flavia Agnes's organization in Bombay. But more recently, in National Law University of Delhi, there was Project 39A. It still continues, but the Project 39A, when it started, was an offshoot of the death penalty project. And it had a team of young lawyers completely dedicated and committed, visiting prisons all over the country, unearthing stories of convicts on death row. And they've had a fairly good success rate in the Supreme Court. And that good work continues today, hosted in Nalsar. It now goes by the name of Square Circle. So these are very inspiring stories. These are good examples of young lawyers, and they can be emulated. And it is for the Bar Council of India itself to encourage other young lawyers to follow this example. The Supreme Court has, on the judicial side, been attempting to bring about reforms in the functioning of the Bar Council of India. The present CJI is taking special interest in this, but for the changes to be lasting and consistent, the changes must come from within and follow a democratic process. A bar controlled by the judiciary does not augur well for either the bar or the judiciary. It is good to see that a protest that started in Jantar Mantar has had ripple effects, and hopefully the dispensation in the Bar Council of India will also wake up and introspect about the number of changes that are required to make that body more responsible. A vision for the bar of 2047 is this: a reformed Bar Council of India that is democratic in its functioning, insulated from interference by the executive and the judiciary, responsive to the needs of the litigant public, prompt in dealing with complaints of professional misconduct by lawyers, and an upholder, and to encourage upholding of constitutional values and human rights. It is time to acknowledge that the present system of having the Bar Council of India determine the course of legal education has not worked, and that is what I'd next turn to. It is trite that for a better crop of lawyers and judges, we need better qualified law graduates. Despite 4 decades of national law universities, not all of the law graduates passing from there are entering the field of litigation in courts. Corporate offices and firms are still more attractive to most of them. Those that have passed through the NLUs or have done a 5-year or 3-year course from the premier legal institutions and choose to litigate are discernibly infusing quality in the bar. And having sat as a judge for 17 years, I am able to sense that with these young lawyers coming into the bar, the quality of the bar is certainly improving. Their internships during the student days have exposed them to the workings of the legal system and have prepared them better to take on the challenges of the legal system. Yet, it is a cause for concern that the quality of legal education in the country is not uniform. There is a growing gap between the top-ranking law colleges and those that constitute the vast majority of the rest. That legal education is in the control of the Bar Council of India has not helped. Even the utility of having sitting judges of the High Courts and the Supreme Court in the governing bodies of the national law universities needs a rethink. It is time to decouple the link between the Bar Council of India and legal education and set up a truly autonomous body for legal education that can set minimum standards that are not diluted in their application. With students being better equipped than their teachers in many of the national law universities, there is a mismatch and there is growing disenchantment and discontent. You find students protesting about the abysmal conditions in many of the national law universities that do not feature in the first 10 ranks. The vision for the law student is this: students who are taught to fight against injustice and who have imbibed constitutional values are more likely to be fearless and independent lawyers, and they in turn will hopefully be the lot from among whom our judges will be chosen. So there have been various attempts at legal reform in the past 79 years. The 3 evils that have plagued our formal legal system are costs, delays, uncertainties. There have been numerous commissions and committees, apart from the Law Commission of India. We've had a national court management system, the NCMS. We have its counterpart in the states. We also have the E-Committee of the Supreme Court. We have the E-Courts Mission Mode project that it is monitoring. So one thing is clear: we do not need any more commissions or committees. I suppose all of you know the 11th commandment. The 11th commandment is thou shalt not committee. There is already enough material for all of us to study and act upon. So we've tried special courts, we've tried fast-track courts. In fact, when the tweet of the Prime Minister was made public that he's going to set up fast-track courts to deal with, paper leak cases, many of us realized that it's going nowhere, because the same existing judges are simply designated as special courts. The same existing judges are designated as fast-track courts. The same existing judges are designated as commercial courts. It's just like wearing a different hat. If you go to a place like Meghalaya, it's the same judge, the same individual judge who's the commercial court, the special court, the CBI court, the court for MP-MLA cases. So we have a great flourish. We do this with great flourish, thinking we've solved problems. We've actually compounded them for the judiciary. Then we have had tribunals. The late Professor Mark Galanter had a lovely way of describing this. He said this creation of tribunals is like creating, bypasses where you divert traffic from the highways. The tragedy in India is very soon those bypasses get choked, and all the traffic in the bypass goes and comes back to the highway, which is already choked by then. So many of these tribunals mimic the practices of courts, and therefore very soon have huge arrears piled up. It's the same lawyers who appear in courts who also appear in the tribunals, and their habits also continue in those tribunals. So the tribunals exacerbate and certainly do not mitigate the three evils that we spoke of: cost, delays, and uncertainties. Then we have arbitration as the alternate dispute resolution mechanism. All of us know how arbitration can only increase costs, increase delays, because for enforcement of arbitral awards, you come back to the courts. And there are huge delays in enforcement. We've now toyed with what is called court-annexed mediation. The judiciary itself is taking the initiative in training advocates and the district judges in being mediators. It's had limited success, I would say, in some of the metropolises, but not uniform success across the country. And there are certain categories of cases that can never be sent for mediation, the chief among them being of the biggest litigant in our courts, the government. Government will never sit for a mediation because the government's processes do not permit it to take a decision at the table of the mediator. We have Lok Adalats and other ADR processes. I don't have time to go into it, but very often in these Lok Adalats, we use the very three negative things: cost, delays, and uncertainties, to pressurize the person in a Lok Adalat to settle for less. So very often, after waiting 10 years and 15 years in a motor vehicle accidents tribunal, somebody who ought to have been paid a compensation of, say, 20 lakhs is having to settle for as little as 5 lakhs or 7 lakhs. And we tout this as a great achievement for the judiciary. And then, of course, we have the informal legal system. We still have the panchayats that mete out verdicts that can be an acceptable form of constitutional point of view. Then we've had godmen, gurus, community leaders, cult figures, local mafia dons with an impressive criminal track record offering their dispute resolution services. They're all outside the rule of law framework. And therefore, in a failed legal system, people are desperately looking for other avenues. We've had a system of court managers. I won't go into it for lack of time. And then I'll dwell on something which many of you would want to know about, which is about the use of technology. Since the early 1990s, we've been using computers in courts. First, we used them as substitutes for typewriters, then gradually to collate data that we fed into the system to produce cause lists. Then we fed data on court websites. We graduated to online filing and paperless courts in Delhi in 2010. Since 2013, we have the National Judicial Data Grid. It's a promising start in making judicial data concerning the district courts accessible in granular form. The e-court project, in the meanwhile, has entered its third phase with a budgetary outlay of over 7,000 crores. And this is something I wish to emphasize. There is no shortage of money for judicial reform. Very often, the judiciary is returning monies unspent, whether for digitization, court infrastructure, or even legal aid. The problem then is to learn how to spend it. COVID-19 brought in a sea change in how courts at all levels functioned. Online hearings, e-filings, scanned files, use of digital devices, live transmission of court proceedings became almost routine. Much of this has continued since then, although it still meets with some resistance from a section of lawyers and the court staff. All across the country, however, the e-courts project is not progressing as well as it should. There are several reasons. First, there is still a digital divide amongst lawyers. Not all of them can afford the smart devices like iPads. Then there is a reluctance on the part of some of the judges, lawyers, and staff to adapt to the changed style of working. There is uncertainty still in many courts of the country of uninterrupted power supply and network connectivity. And above all is the centralization of the management of the digitization project with the e-committee of the Supreme Court. The insistence by some courts that lawyers should, apart from e-filing the case, also supply hard copies of the paper book is a disincentive. By now, we should have had paperless courts at all levels of the judiciary, digitalized all court records, past and present. We could have had a dedicated cadre exclusive to the judiciary for technical support services. This transformation is even now possible. This is the only way forward if our courts have to stop being paper guzzlers with overflowing records spilling over every available floor space. This calling for the records not being found in court, cases getting adjourned for that reason is an endemic problem. And very often a lawyer will simply stand up in court and tell the judge, please call for the record, which means if it's the record of a court against whose decision appeal is being filed, that court will not continue to deal with the case. So we have had this instance, and this is a real instance, of this judge in the Delhi High Court. He was a very, very patient judge and doesn't show too much reaction while the case is being argued, and is known to be measured in his response. So the case was called out. It was a case of prayer for grant of an interim injunction. So naturally the lawyer is very anxious. So the minute the case was called out, the lawyer took off. And he's a senior lawyer, went on non-stop for about 20 minutes till the instructing lawyer pulled the gown and said, let's find out what's happening on the other side. So when there was a pause, the judge turned to the stenographer and said, Likhiye, file not received, re-notify on. Basically, the judge was not even, telling the lawyer, because he was supposed to be a patient judge and he didn't want to interrupt the lawyer. And it left the lawyer completely clueless as to what to do. So this problem of records being stuck in our courts is something that can easily be overcome if we resort to digitalization of our court records. It will free up space in the court and it will help, cases move faster. There are several reasons why many of these measures have not worked. First, our entire legal system revolves around the convenience of lawyers, judges, and the state. They are not litigant-centric. Even today, it is not possible for a litigant to navigate the legal maze without professional legal help. The entire legal system, which includes the judiciary, is only catering to their own convenience, and every attempt at legal reform without inputs from the actual users of the system is bound to fail. The harsh truth is that the system of judicial administration in these 79 years has not been as democratic and accountable to its users as it ought to be. A vision of the legal system of 2047 would be the completion of the unfinished task of what we call process reengineering. We have so many meaningless forms and registers to fill, forms of address of petitions, and all of this should change. This should happen with the help of technology. By 2047, we should have completed this task, and this should be based on hard data. This time it must happen in an open, transparent manner and in consultation with the users of the system. Second reason why these reforms fail is that we are not a society that is attuned to accepting a rule of law paradigm. The complete internalization of constitutional values at a personal and societal level is yet to take place. Social democracy, as envisioned by the constitution makers, is still a work in progress. Baba Saheb Ambedkar's prophecy of our country entering into a life of contradictions on 26 January 1950 should hopefully not hold true for 26 January 2050. A cause for concern is that even after 79 years of independence, those in power continue to betray Ambedkar's vision of constitutional morality. Today's citizen is very often alarmed to find that those in power themselves do not adhere to the rule of law. The prospect of state anarchy is precisely why we have a constitution. Its primary purpose is to place checks on the abuse of state power. The judiciary's track record in delivering on the constitutional promise of being a bulwark between the people and the anarchic state has at best been inconsistent and quite often disappointing. The attempts at creating a false equivalence between fundamental rights and fundamental duties misses the point about the obvious imbalance between the mighty powerful state that monopolizes the use of force and a citizen seeking the protection and enforcement of the basic survival rights to life and human dignity. Third, and this reason is important, our lawmaking processes are by and large top-down. The people likely to be impacted are seldom consulted. The language of the law makes it difficult to comprehend. Very often, laws are passed without any meaningful debate or discussion by our members of parliament. When one regime is successful in bringing laws using the bottom-up approach, like the Right to Information Act or the Land Acquisition Reforms Act of 2013, of the Food Security Act or the Forest Rights Act or the Manrega, the succeeding regime will work to undermine it, dilute it, and make it ineffective. Where the attempt is to bring about social transformation through law, the process of top-down lawmaking easily alienates the people. Naturally, they're reluctant to accept as a binding norm of social behavior. This explains the failures of the Dowry Prohibition Act, the Child Marriage Restraint Act, the Bonded Labor Act, the Child Labor Act, and other similar enactments. Courts can do little to persuade acceptance of laws by the people. It is often saddled with the consequences of their failure. The fourth reason is this. Governments and legislatures have failed to seriously take the concept of judicial impact assessment, on which two expert committees have submitted reports. Every change in an existing legislation and every new enactment has the propensity of increasing the work of the courts manifold. The 1988 amendment to the Negotiable Instruments Act that criminalized as an offense the bouncing of checks increased the workload of our magistrates' courts hugely. As of today, we have 40 lakh check bouncing cases that make up nearly 40% of the total pendency of criminal cases. Therefore, decriminalizing the offense of check bouncing and restoring the status quo is actually no-brainer. Fifthly, all reform in our pyramidal structure has to start at the top. The initiative has to come from the Chief Justice of a High Court or the Chief Justice of India. If we are going to have persons in these positions, not even for a few months, and sometimes it is for a few days, then the kind of reforms one needs for complete overhaul will simply not happen. If the CJI shows interest in accelerating the pace of digitization uniformly across all courts, it is likely to happen. The next best thing to do is to learn to delegate, broad-base the system of judicial administration, have a continuous monitoring of the implementation of the numerous reports that have already been submitted and are waiting to be acted upon. Both the E-Committee and the NCMS should not be the sole preserve of the senior-most judges of the Supreme Court. It should have judges lower in the pecking order, judges from the high courts who are likely to remain in the system for 10 years or more, and a fair representation of domain experts that can help steer the reform implementation process. The process must be consultative. It cannot just be a three-way dialogue between the bar, the bench, and the government. The judiciary must take the initiative to organize the conduct of surveys to find out what the users of the system need and would want to change. Our reforms have to be litigant-centric. Lastly, and this is important, the vestiges of both patriarchy and feudalism in the judicial administration is palpable to anyone who has seen its inner workings. There is an obsession with protocols, arcane forms of address, and usage of expressions. When Justice A.P. Shah was the Chief Justice of the Madras High Court, when he traveled by road from Chennai to Madurai, he found that at every toll gate of every district crossing, there would be the district judge, the local magistrate, all waiting to greet him. And he said, what is going on? Why are these people not sitting in courts and waiting to receive? They said, no, it's part of protocol. Your lordship is traveling, so we have to pay our respects. Then he lands up in one of the districts, and he's walking around the court. He finds a stray circular. Somehow someone has forgotten to put it back into the drawer. It says, please contribute to his lordship's entertainment fund. The entire court staff is supposed to contribute a part of their earnings to build up a fund, because every time there's a visiting judge, either from the High Court or the Supreme Court, that judge has to be entertained, and the money is provided by the staff. So all of these are actually vestiges of our feudal system, of a patriarchal system, where you have to appease the so-called boss. This is an anachronism inherited from the colonial past that has survived 79 years. This needs to be acknowledged, interrogated, and dismantled. What else must we do today? Let me at this stage acknowledge that if there are many aspects touching legal reforms that I have not talked about, it is for both want of time and the fact that they've been discussed extensively in public fora. I have not talked, for instance, about the much-needed reforms in the criminal justice system, among the police, in the prisons. I have also not spoken about inconsistent decisions given by the High Courts and Supreme Court, which add to the uncertainties, and there is no finality even in judgments of the Supreme Court. But this I certainly want to talk about. The practice of criminalizing choices that an individual makes about whom to marry or live with should be halted. And I have specifically in mind the spate of uniform civil code legislations that have been passed in some of the states ruled by the BJP. Law should not be used to target a group for what they wear and what they eat. The India of 2047 would be better served if the law of today does not permit criminalizing honest criticism of a government or of those running it, or of their being lampooned in cartoons or joked about by stand-up comedians. The India of 2047 would be better served if the government of the day stops weaponizing law to punish those who peacefully protest about the denial of basic rights, and if it stops labeling them as sinister acts of conspiracy to destabilize the government. The India of 2047 will be better served if the plethora of preventive detention legislations and the draconian bail-denying provisions of the UAPA and the PMLA and other similar enactments are repealed. In 2047, such enactments should be accessible only in parliamentary and judicial archives. The judiciary of 2047 will be better served if today's judges act swiftly on complaints of grave state excesses. The Supreme Court of 2047 will hopefully not wait for over 4 years to decide whether reducing a state to a union territory is constitutionally valid, over 6 years to decide whether an overnight decision to demonetize currency was legally permissible, over 6 years to decide whether anonymous contributions to political parties through the device of electoral bonds was valid. Our future generation should be able to recall as things of the past the low points of our judicial history, never to be repeated. The judicial stamp of approval to the draconian emergency of 1975, the inability to deal with cases of mass crimes whenever they occurred, the gross injustice in the case of mass torts like the Bhopal gas disaster, the failure to take up and decide in good time habeas corpus petitions, complaining of unlawful detentions, of petitions complaining of encounter killings, of disappearances, of arbitrary demolitions of homes of dissenters and minorities, of brutal crackdown on tribals protesting against locating of projects in their habitats, signaling their imminent displacement. In 2047, an Indian should be astonished to discover that in India's past, there was a time when laws would punish the poor for who they were and not for what they did. When a sex worker and not her exploiter would be punished, when a neglected juvenile and not her tormentor would be punished, when seeking alms would be a crime as would be sleeping on a pavement for want of shelter. They would, in 2047 and later, I suppose, also be astonished that the Supreme Court would, after declaring unreasoned orders of internet takedown to be unconstitutional, refuse to enforce its judgment. After declaring that unannounced and arbitrary demolitions of homes of protesters, particularly the minorities, is legally impermissible, failed to enforce its own directions. In this vision of an India of 2047, a sincere effort by our generation to revitalize the constitutional values of social justice and fraternity would have borne fruit. There would be no more manual scavenging, no more sewer cleaning by human beings, no more rack picking on landfills by tiny children, no exploitation of labor, whether bonded labor or child labor, no dowry burnings, no female feticide, no witch hunting, no sex-selective abortions. Our generation should have, in the ensuing decade, worked at ending mob lynching and public humiliation of Dalits by the upper castes, targeting of religious minorities in the name of God, and an aggressive assertion of the religious superiority by the dominant groups. If the judiciary of 2047 should be relevant to the people and be able to afford the meaningful redress of their grievances, our present judicial academies should orient our judges on issues of law and poverty and organize courses that serve to remind them that the judiciary is there to protect the people against the excesses of the state and powerful dominant groups, strengthen their arms in the demanding greater accountability and transparency from the state. If court themselves and their processes turn into sites of oppression, it will undermine the faith of the people in the justice system and its ability to deliver fair and equal justice. The growing inequality in wealth and power, both externally and within the country, is a cause for concern. And so is the bitter truth that our governments are controlled by corporate oligopolies here and abroad to serve their interests. Worrying also is that democratic processes can be subverted to install electoral autocracies that soon thereafter seize control of all institutions of accountability. that technology can be weaponized to keep an entire people in a permanent state of surveillance and reduced to a string of digits that serve as their only identity. To top this, that a few powerful foreign corporate powers can control all the information about us and share it at their will with oppressive regimes that have little respect for the rule of law. All this is here and now, and I have not even mentioned yet climate change and the impending catastrophes on that score. But as history reminds us, there is hope. The recent protests by a Gen Z assure us that democracy in India will not be allowed to die and that people will turn to the Constitution and safeguard it in order to preserve this country's future. The week of 20th July this year was one of relief and joy. It was reassuring to know that our young generation will not be swayed by rhetoric and propaganda, by powerful oratory reminiscent of the Goebbelsian polemic, and empty promises of Achhe Din and Viksit Bharat. They remained undeterred by the demonizing of the Dimagi Naxal. It told us that this generation values giving, compassion, and adherence to truth. It does not hesitate to ask questions of those in power. And of course, Gen Z have a wonderful sense of humor. The irreverence of the Gen Z is a sure sign of democratic progress. This is the last part of my speech. I call it a dream and an awakening. Let us now give ourselves something to cheer about. Let us collectively dream of 24th August 2047. That evening, I'm sure, introductions have been done by Avya, Adhyapat, and Hridaya. And their mothers and parents are sitting in the audience. A day when we find there is no Trump, no Putin, no Xi, no Erdogan, and India has a biological prime minister. India is at peace with her neighbors. Delhi's pollution has disappeared. The Ganga and the Yamuna are clean. The south is still part of India. India's colors, smells, food and flavors, music, dance, art and festivals, languages, dialects, vibrancy, inclusivity, plurality, its gods, godmen, religions, cults, sports heroes, its madness about cricket and obsession with films and film stars, and above all, the resilience and never say die spirit of her people are all intact. India's borders are not forbidding. There is peace, everlasting peace. It's too unreal, isn't it? And yet, to shake us up from this reverie, just to remind us that this is India, there is chaos, anxiety, stress, the endless traffic jam, vehicles coming on the wrong side, there is jugaad. And somewhere in some part of India, there's still an overburdened court with its lawyers on strike. And somewhere in that court is a lost elderly litigant, unable to comprehend the mystifying court process and the even more mystifying court language. Tired of waiting for his lawyer to turn up, he steps forward to argue his case in the local tongue. After indulging for a while, the Chief Justice remarks, देखो बाबूजी, जो आप कह रहे हैं हमें समझ में नहीं आ रहा है, आप वकील रख लो. The elderly litigant clearly puzzled remarks, कमाल है, समझ आपको नहीं आ रहा है और वकील मुझे रखना है. Thank you.